by one and try to get through this process as quickly as possible. Now that everyone has been qualified this morning, I'm going to explain to you a little bit of the process and how it's going to take place. The first thing that we're going to do is discuss with you individually what you may know about this case. This case has received a fair amount of publicity, and there was also a related trial that took place about a year ago. This process is going to be handled individually because you do not need to know what others may know concerning this case if they have prior knowledge at all. Before we start any individual questioning, I'm going to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices that you may have brought to the courtroom with you. Even though you have not yet been selected as a juror, there are some rules that you must follow, even as a prospective juror, concerning your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out anything that is related to this case. Between now and when you have been discharged, you must not provide or receive any information about your jury service to anyone, including your friends, coworkers, and family members. You may tell those who need to know where you are and that you've been called for jury duty. If you are picked for the jury, you may tell people that you've been picked for a jury and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. You must also warn people not to try to say anything to you or write to you about your jury service or the case. This includes face-to-face, phone, and computer communications. In this age of electronic communication, I want to stress to you that you must not use electronic devices or computers to talk about this case. This would include tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all. Do not send or accept any messages, including email or text messages about your jury service. You must not disclose your thoughts about jury service or ask for any advice on how to decide the case. Further, you must not read, listen to, or find any news accounts related to this case until you have been excused. Avoid the newspaper, television broadcast, and particularly the local news stations. Also, avoid social media or any internet news sites. I am now going to provide to you a statement of the case that has been agreed upon by the parties. On July 18th, 2014, FSU College of Law professor Dan Markel was shot while seated in his car. This happened in the driveway of Markel's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green colored Prius. The defendant and alleged conspirator in this murder was the former brother-in-law of Dan Markel and has entered a plea of not guilty. The statement of the case that I've just read to you is not evidence and is not to be considered as evidence or any proof of guilt. You must not be influenced by this statement. It is merely informing you of the accusation that has been made by the state against the defendant. Before we speak with you individually and privately about this case, some of you may be excused. The rest of you will remain to participate in the next phase of the jury selection process. Individual voir dire is time-consuming, but it will go a lot smoother if you're prepared to tell us what we need to know when each of you are brought back to speak with us. These are the basic questions that you will be asked. What do you know about this case? What are the sources that you've obtained this knowledge from? Based on what you know, do you have an opinion about Mr. Adelson's guilt or innocence? Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence that is presented in the courtroom? Can you be fair and impartial? Do you have any reason that you cannot serve on the jury for potentially up to 3 weeks? It will save us all a lot of time if you think about these questions and you're prepared to give an answer to each of the questions when you are called back. As it relates to the hardship aspect of this, we expect the jury selection process to possibly take up through Thursday of this week. After that process is complete, we will begin the trial with opening statements and calling witnesses. All in total, we expect that these proceedings from today may potentially take 3 weeks. We understand it is a burden for anyone to serve for that length of time. However, we cannot make our system of justice work unless we have good people that are willing to do their civic duty and serve as jurors. Similar to those in military service, we do have to call on our citizens to make serious sacrifices depending on the situation. Jury duty is one of those times. You will probably never be called on again to do something like this. However, I understand for some of you, this may not be possible given the length of time. To give you a little more information about what it will involve, you will not be sequestered during this trial. You will be permitted to go home at the end of each day and to return the next. For the most part, we will work a regular business day, trying to keep a schedule somewhere between 9 a.m. to around 5 p.m. On occasion, it may be necessary for you to work a little bit longer based on the witness schedule. I will do my best to adhere to keeping this schedule. So please give it some thought to whether any of you would have a major problem, including a physical problem or issue, that would prevent you from giving this case your full attention and performing your duties as a juror. Please be patient with us. We will be working as efficiently as we can this morning. The bailiffs, the clerks, and court administration will be assisting here in the courtroom. While you remain in the courtroom, please follow the bailiffs or clerk's instructions. Do not discuss this case while you're waiting or anywhere else until you have been excused. Please do not read or listen to any media accounts on your phone or anywhere else, also until you've been excused. At this time, I would ask for the attorneys and the court reporter and the clerk to go ahead and move into the jury room to get set up. Prospective jurors, we will call you back one by one and try to get through this process as quickly as possible.
As you can see, the team representing Charles Adelson has increased in size. Now they have retained Josh Dubing, who is a well-known trial strategy, jury selection attorney expert with a background in psychology. He's going to help with the decision-making process during jury selection and also with some trial strategy and preparation of witnesses, which is what I'm assuming that he's going to be doing, of course, based on his background. He may also help, for example, prepare Charles Adelson to testify if that's going to happen. So he's going to be helping out on the team. He's going to be in and out during the trial. He's going to be participating throughout the whole process in the jury selection process. And I found a prior recording of an interview that he gave during the Drew Peterson trial, which Drew Peterson was convicted of the murder of a former wife. And I thought that the comments from that trial about 10 years ago were quite applicable to the situation that we have here today. So here we go. Let's check it out.
White and jury consultant Josh Dubin with us now as we talk about the fact that some of these jurors who have been chosen are divorced. And we know that that's something. In fact, I was just watching the local news here in Joliet, the news out of Chicago last night. And I know that a couple of the attorneys, the defense attorneys, were on last night as well, saying, look, we got the jury we wanted. We got a couple of people who are divorced who can understand what a contentious divorce is. I want to bring in Josh Dubin here as a jury consultant. Josh, is this a good jury for the defense, the prosecution, both, in your opinion?
Well, it's really difficult for me to say that without having sat through voir dire, because I think that there's no bright line test in terms of whether or not a juror has been divorced or not, because I could see it easily cutting both ways. So let me give you an example. For a male juror, and I think it's juror number 5, who's been divorced, he could, look, we all make decisions based on our life experiences. So there's no doubt that jurors that have been through a divorce are going to relate back to their own experiences as a foundation for the decision-making process. But I could easily see juror number 5, who's a male, saying, listen, while my divorce may have been acrimonious, I never, ever thought about harming my spouse or ex-spouse. Whereas a female juror who had been through an acrimonious divorce and had thoughts like, boy, I hope he never hurts me, or felt threatened in any way, I could see cutting against the defense. I'd be much more concerned with how these jurors have been exposed to media about the case, which I think is would be the biggest concern for me.
Peterson, Josh, let me ask you, one of the things that keeps coming into play here is the fact that the jurors are not supposed to consider Stacey Peterson's disappearance in this trial. But you can't get away from it, because had it not been for her disappearing, Kathleen Savio's body would not have been exhumed, and we wouldn't be sitting here today. So let me ask you, can jurors, you're a jury consultant, you know what they're able to do, can they disconnect enough, do you think, from Stacey Peterson in that situation to look at this objectively, fully?
Absolutely not. I mean, having just come off of the Darun Ravi case, to ask jurors to do that, to ask jurors to somehow compartmentalize such an incendiary fact and to somehow put it out of their thought process is discounting human psychology at its most fundamental level. Just think about this for a second. And this is something that attorneys go through day in and day out picking juries across this country, which is this fundamental erosion of the presumption of innocence. Because what's going to happen here is that there's going to be and the judge is going to try to limit the amount of information that jurors hear. But what tips off the investigation into this case is the disappearance of Mr. Peterson's wife. So what you're asking jurors, the judge is not, there's going to be no evidence that she's dead, missing. Jurors are going to make assumptions. And it's just very, very difficult to ask jurors to compartmentalize information. And my biggest concern in a case like this is everybody that has been exposed to the media will invariably be asked some form of the following question. All right, I know you've read about the case and you've said you have an opinion. Can you put that aside? And in the words of my client and friend, Roy Black, he always says to me, well, I feel like asking the prospective juror, where are you going to put it? We're not that efficient. We're not machines. We have feelings, and our thought process just doesn't work in a way that allows us to compartmentalize facts and feelings like that. It just doesn't work that way.
Yeah, very good point.
I think that they're going to look at the evidence that's presented inside that courtroom and not anything that's outside.
All right.
I
Thank you so
think
much.
that's
Judge White. Josh, go ahead.
I just think I think that just quickly, the last point, that is a fundamental problem with our jury system, is judges across the country repeatedly asking jurors, do you think you could put that aside and be fair and impartial? When a juror makes an expression that I've read something and I have an opinion, the inquiry should end there. We should move on. There's this rush to get through jury selection. We should be very, very measured. I mean, we're dealing with whatever you think about Drew Peterson, we're dealing with somebody's freedom here. We should err on the side of caution and excuse prospective jurors when they equivocate at all about their fairness, because we are not efficient enough to be able to compartmentalize what we have seen and heard, especially what we've seen and heard in today's media savvy society. You think there are any headlines out there that say, hey, Drew Peterson looks like we should give him a fair shake? He hasn't done himself
well,
any...
there was a headline today. There was a headline in the Tribune saying that the prosecution's got an uphill battle. So I think part of it is out there, but you're right. The question is how much can they disconnect from it, and are they even able to do so? Of course, then you look at Casey Anthony, where people were in an uproar about that trial, but look what happened at the end of the day. Clearly, they were able to do it. But Josh Dubin, you bring up some great points. I want to thank you for being with us here, jury consultant there.
Thank you.
So by hiring Josh Dubin, they also got access to a PhD guy, Dr. Bill Wenzel, who specializes in the data of jury selection. And he's present there in the courtroom as well. He's going into the questioning of the jurors that is happening during the phase 1 of jury selection. And remember, the jury selection is going to happen in 2 phases. Phase 1, each person is going to be questioned individually about their prior knowledge about the case. 2 phases for jury selection. The first phase is when they're going to throw away most of the people who have hardship and cannot be in a trial that is going to last 3 weeks, or the people who have prior knowledge about the case. So the first phase is the individual questions, and then the second phase is when they get to about 60 or 70 people that have been pre-selected, that could be fair, that could serve in a 3-week trial. That's when they're going to do the group questioning. And that's where Dr. Wenzel and Josh Dubin are going to show how much they're worth, I guess, for the defense team. They're going to do their best to pick the best jury possible, a jury that will be sympathetic to the arguments and to the position that the defense will advance during the trial. We, of course, do not know exactly what that will be. We expect it to be that it was Wendi, or that the state cannot prove that it was Charles, that likely it was Wendi, but we do not know that for sure. So obviously the defense team and the people picking the jurors for the defense, they know whether the defense will be, and they can decide then what angles, what issues, what biases they're going to be exploring or asking questions about during jury selection. Thanks for watching Mentor Lawyer.